In the courtroom, every word matters, but today, it's the silence that speaks volumes. We're diving into two cases that couldn't be more different, yet both expose the raw, unfiltered consequences of personal choices. First, a man walks in and makes a stunningly casual admission about his drug use, an admission that has the judge immediately taking him into custody, but that's just the warm-up. The main event centers on a young mother, Kayla Rawlig, facing the unimaginable charge of abandoning her child. Her 2-year-old daughter was found wandering the streets, alone in the cold November air, wearing nothing but a diaper. The prosecution calls it gross negligence. The defense calls it an honest mistake. As a Child Protective Services worker gives a glowing report of her progress, the judge remains unconvinced, her sharp questions cutting through every excuse. With freedom on the line, the judge makes a sudden demand that will either prove Kayla's redemption or seal her fate.
Just real quickly.
Yes.
The last 3 times I've been in here, you made a reference, and so
Okay.
about suspenders.
Yes, Once Upon a Time in the West. Thank
And the law.
you. With Henry Fonda. Yeah, do you know what? That is one of the best Westerns
It is.
that has ever been made, and so few people have seen it.
I agree.
Until you've heard what I've come to say. You have said enough.
Anyway, I was just.
Thank you. That is so true.
Yeah, I have full experience.
Okay, just one second. Let me write this note.
This is a jaw-dropping moment. The judge asks Mr. Hernandez how often he's using meth, expecting denial or a downplayed answer. Instead, he casually, almost comically, responds, 3 times a week. The judge's follow-up is key. She points out he knew he was coming to court, meaning this isn't old news, this is an active, ongoing problem. His response, what does that mean, is either a sign of profound impairment or a stunningly detached attitude toward his situation. He seems to think using meth 3 times a week isn't a lot, a delusion the judge immediately shatters. Notice her tone. It's not just punitive, it's a pivot to action. She states she's not doing this as a punishment, but to get him help. He's immediately taken into custody, not just for the offense, but for his own survival. Because as the judge puts it, this path is not going to end well for you.
All right, Mr. Hernandez, how are you doing today? Oh, I'm doing great. All right, when you're drug tested today, what are the results going to be?
I'll probably say positive.
Positive for what?
Nothing.
Could everyone please whisper? All right. How often are you using meth? No, it has to be, you knew you were coming to court today. So for you to be positive for meth, that means you used knowing you had to be in court today. So again, how often are you using?
Not often.
What does that mean?
Let's say 3 times a week.
All right. That's often.
That isn't funny. Yes, it is!
All right. So we're going to try to get you some help. We're going to do a UA today. And you're going to be taken into custody today. And we're going to try to get you some inpatient treatment, okay? All right. Can you UA him, please? Zane Hernandez. All right. So, Mr. Hernandez, we're going to.
With Mr. Hernandez sent for court-mandated treatment, the docket turns to the main event. The atmosphere shifts as we move to the case of Kayla Rawlig, and the central allegation is every parent's worst nightmare. We're not talking about a moment of simple inattention. We're talking about a 2-year-old child found wandering the streets in November wearing only a diaper. The prosecution is here to argue this was an act of criminal negligence, while the defense will attempt to frame it as a tragic misunderstanding. The first person to take the stand is a caseworker from Child Protective Services, the very agency tasked with ensuring this child's safety. Her testimony is about to create a fascinating conflict between the mother's reported progress and the cold, hard facts of the incident itself.
Make sure you have treatment, because you using meth that amount of time it's not going to end well for you. All right. Do you have children? All right. Where are you staying? Are you staying with someone? Your mom? All right. So we'll be sure to make sure that we have your mother's number and let her know. And we're going to get an attorney appointed for you before you leave here today. Okay. All right. So we can do the UA, and if you can file a motion to revoke. And I'm not doing this as a punishment to you. I'm doing it so that hopefully you'll become clean and sober, because otherwise it's not going to end well. And when you think that using meth 3 times a week is not a lot, that's a lot. Okay. All right. Thank you. Okay. Yeah. Is the attorney here for, thank you, counsel. All right, so we're back on the record in 2022 CR 9351, State of Texas versus Kayla Rolag. And you're still under oath. And could you restate your name, please?
Yes, Cynthia Cisneros.
All right, and standing in for the state?
Ruben Herrera for the state, Your Honor.
All right, counsel, you may proceed.
You stated your name. What is your profession, occupation?
Yes, I'm a family-based safety services worker for Child Protective Services.
And have you supervised or participated with Miss Kayla?
Yes, sir. I have been her worker since September of 2022, and her case just recently closed here in February.
Okay, and can you tell the court how you have interacted with Miss Kayla and how has she progressed?
Sure. So, part of my job is to obviously, go into the home, make sure, things are going well with her and her daughter, also to comply with services. So specifically, we had enrolled Kayla Rolag into parenting, domestic violence, and random drug screenings. She excelled the whole time. She also got protective daycare for her child. So that's where she currently is during the day. And then she does reside with maternal grandmother and Kayla during the day. But she did really, really well. All drug screens came back negative for all substances. She was compliant in all of her services, received positive feedback from all her providers.
Here comes the prosecution, and he's not pulling any punches. He immediately reframes the situation from a mistake to a deliberate act. He uses powerful language like gross negligence and lack of proper judgment. The most damaging part is his assertion that the defendant admitted to leaving her child purposefully at the home without confirming an adult was present. This directly attacks the defense's honest mistake theory. He's painting a picture of a mother who made a conscious, reckless choice. And then the judge intervenes, not about the facts, but about the emotion. Kayla is crying and the judge shuts it down cold. Tears don't sway the court. This is a stark reminder that this hearing is about accountability, not sympathy. The judge is signaling to everyone that she will not be manipulated. She's here for facts, not a performance.
And my time in working with Ms. Rolag, I really did not experience any negative feedback, any negative experiences or anything like that.
All right. And are you fully satisfied that she has participated well then?
Yes, definitely.
As a witness?
Mrs. Cisneros, does the defendant have a support system in order to help her care for the victim in this case?
Yes.
And is she?
The defense attorney immediately goes into damage control, and his primary tactic is semantics. Notice the deliberate word choice. The prosecution said the child escaped, which implies a prison-like environment she needed to flee. The defense counters that she wandered off, a phrase that sounds far more innocent, something any toddler might do. This is a classic legal strategy to soften the perception of negligence. He then attempts to shift the blame, stating his client thought other adults were home. This frames it as a failure of assumption, not a failure of care. He's trying to build a narrative of a young, perhaps naive mother who made a mistake, not a neglectful one. He knows the judge is a tough audience, so he's putting Kayla herself on the stand to sell this story directly. It's a risky move that could either save her or sink her completely.
Nothing further, witness, Your Honor.
All right. So how long did you supervise her?
Oh, since September of 2022.
And how
So-
often were you seeing her?
I was seeing her about twice a month.
All right. And when's the last time she had a drug test?
February of this year.
Okay. All right. Thank you.
Thank you.
Your Honor, if I may, Ms. Kayla would like the court.
You state how you reviewed the documentations he wants to present to the court.
The judge just dropped a bombshell that completely undermines the defendant's credibility. She brings up the pre-sentence investigation report, or PSI, and points out that in that official document, Kayla was blaming the people who CPS has put in charge of helping her. This is a massive contradiction. In the report, she pointed the finger at others, but now in open court, her lawyer is trying to frame it as an honest mistake on her part. The judge is calling her out on this inconsistency. She's essentially asking, which is it? Are you the victim of other people's irresponsibility, or are you the one who made the mistake? This moment forces Kayla to choose a narrative and stick with it. The judge's skepticism is palpable, and she's making it clear she's not just listening to today's testimony, but comparing it against everything Kayla has said before.
No, did the world treat you bad?
Of no objection to the presentation of the state's doc, or the defense documents. Your Honor.
Approved.
Yes. Thank you, counsel. And for the record, the court is reviewing certificates that have been offered on behalf of Ms. Rolick by her attorney.
That the defendant seems to be taking some steps in,
All right, you all need to whisper in the box.
taking responsibility for this matter. Based on the allegations, Your Honor, it shows.
This is a master class in judicial questioning. The judge isn't yelling or being aggressive. She's using logic and common sense to dismantle the defendant's story. Her analogy is brilliant. Unless people are living in a mansion and you have the West Wing and the East Wing, how do multiple adults leave a home without anyone realizing a 2-year-old is now alone? It's a simple, relatable scenario that exposes the implausibility of Kayla's explanation. Kayla's defense is that she just thought her mom was in her room, but she admits she didn't see anyone or hear anything. The judge's final question is the checkmate, so you don't see anybody and you just leave your daughter in a house. It lays the core negligence bare. It wasn't a complicated series of unfortunate events. It was a simple failure to check.
Gross negligence and the lack of proper judgment. In fact, if the defendant did admit to leaving her child purposefully at the home without checking to see if there was anybody there.
And here is the ultimate test. The judge is clearly on the fence. On one hand, she has a CPS worker saying Kayla has been a model of compliance. On the other, she has a story about the incident that, in her own words, she finds hard to believe. She can't reconcile the two. So she resorts to a definitive scientific measure of truth, a surprise urine analysis. This is a brilliant judicial move. It cuts through all the testimony, all the tears, and all the excuses. If Kayla has truly turned her life around as the CPS worker claims, this test will prove it. If she has been putting on an act for the court, this test will expose her. The entire outcome of this hearing, probation or prison, now hangs on the results of this one test. The tension in the room must be immense.
Supervise the child, Your Honor. This resulted in the victim child being able to escape the residence on her own, being outside in cold temperatures with nothing but a diaper on. Based on the allegations, Your Honor, the state would oppose the defendant's.
This is the moment the entire case pivoted. After a tense wait, the judge announces the results of the surprise drug test, negative. You can almost feel the collective exhale from the defense. This single piece of evidence is more powerful than any testimony given so far. It validates the CPS workers' report and proves that, at least in this crucial aspect, Kayla is walking the straight and narrow. It lends credibility to her claims of trying to be a better mother, even if her judgment on the day of the incident was deeply flawed. For the judge, this negative test provides the something she needs to justify leniency. Without it, given her skepticism about the story, the outcome could have been very different. The defense's request to remove the ankle monitor is swiftly denied, a sign that while the judge is pleased, she's not letting her guard down yet.
Application.
All right. Is there a reason for the tears? Because what he's just saying is true.
No,
Now, I know people want to cry before the court because they want the court to be lenient,
it's not.
but let me just tell you, tears don't sway the court. I'm just here to listen to facts to see if you've done anything that would justify the court placing you on probation. Okay? All right. So that's why you're asking for her to go to prison?
Yes, Your Honor.
All right. And have you State, have you had a chance to review her certificates?
I did, Your Honor.
All right. All right. Defense?
Yes, sir. And, Your Honor, we're asking that the court consider supervision for her. This offense, first of all, the child just wandered away from, in contrast to what counsel says that the child escaped. So it wasn't a matter of escaping. She was just wandered off as children off too. My client had stated, she told the police that she thought that the adults were inside the home and that the child was being taken care of. And it was just a mistake on her part. And I would like for Ms. Rolak to address the court on this issue of abandoning the child.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record.
Kayla Rollock.
All right. Defense?
And why do you, first of all, was this an honest mistake on your part in leaving the child?
Yes, I would never want to leave my child on purpose. I take care of her every day. I'm the only person that she's been with every day of her life.
The judge's sentencing speech is incredibly insightful. She begins by acknowledging that on paper, Kayla should probably go to prison. But then she delivers a crucial lesson. Don't come in and throw yourself on the mercy of the court, and you have done nothing. She is explicitly rewarding Kayla's actions, completing her programs, getting her GED, and enrolling in college. She's making it clear that it was Kayla's own hard work, not her lawyer's arguments or her tears, that earned her this second chance. The sentence itself is what's called deferred adjudication. This means if Kayla successfully completes her 4 years of probation with its very strict terms, the conviction can be dismissed from her record. It's a significant opportunity, a tightrope walk with severe consequences if she falls. The judge is balancing public safety with a belief in rehabilitation.
I love her and I didn't mean to put her in any harm's way.
All right. Somebody want to explain to me the crux of this entire situation is some kind of way, a 2-year-old in a diaper ended up wandering the streets in a diaper only in November, and it was cold. So, I mean, that's what we need to get to the point of, because in the PSI report, she's blaming the people who CPS has put in charge of helping her supervise the child. That's who she's blaming for her child being out and about, because in the PSI report, it states that guilt was minimized. And in the PSI report, she's stating she thought these other people who CPS put in charge of her child as the person to chaperone or supervise, she's blaming them, saying that they were supposed to be there. So somebody explain to me how a 2-year-old gets out of a apartment or residence that's supposedly locked or should have been locked.
So she was naked, not wearing any clothes, because that's how we sleep. She still goes and runs around naked. We just got out of diapers, so she usually just wears a underwear. But that's why she was naked and not having any clothes. And I do not blame anyone else. This is my fault. I should have been the one to check if anyone was there. I was just saying that I had thought because when I laid down my daughter, my mom and my uncle were still there. So that's the reason why I didn't check. But this is my fault. I am taking full responsibility.
Okay, I hope everybody understands. I'm always curious. I have questions. It sounds odd to me, unless people are living in a mansion and you have the west wing and the east wing and people leave and people don't know it. So I'm just finding it, or I just have questions. How a child gets left, and I don't even understand how children get left in the car by themselves, but in a home, how does a child get left in a home by themselves if a parent is leaving and other people are there? And
The conditions of this probation are strict and specifically tailored to prevent a repeat offense. The judge is using her experience to target the root causes of these situations. The rule that no adult males can reside in the household is a powerful and proactive measure. The judge explains her reasoning, citing her experience as a defense attorney where a new, unvetted partner often derails a mother's progress. Furthermore, she's requiring monthly field visits from probation, meaning they will be coming to the home, not just having her check in at an office. This provides an extra layer of supervision for the child's environment. This isn't just a standard issue probation, it's a highly structured, hands-on plan designed to give Kayla the support she needs while ensuring the child remains safe. Every condition is a direct response to the risks identified in this case.
other people see you leave. Nobody thinks, oh, we can't leave because there's a 2-year-old here. How does that work?
So when I laid down my daughter, my mom, my mom and I both went into our rooms. That's why I thought that she was there. So I didn't hear no door open or close, and I hadn't come out of. So I didn't see anybody. I figured my mom was still home because I didn't see anybody out there.
So you don't see anybody and you just leave your daughter in a house and you haven't seen anyone?
Just because I thought that my mom was in her room still.
Defense, you may continue.
I have no further questions, Your Honor.
Any questions?
Just briefly, Ms. Rolak, how far away is your mother's room from your room?
It was down low.
Did you knock at all to check if she was still there?
I don't think so.
Did you walk around the apartment to confirm that there was any adults present before you left the apartment?
I just walked through the living room.
Nothing further else.
All right. Any other witness defense?
No, Your Honor.
All right. I want a UA today, then I'll make my decision. All right. So, Ms. Abrams, if I could have a UA on Ms. Rolak, please. All right, we're back on the record in 2022 CR 9351, State of Texas versus Kayla Rolak. Court is here. Counsel. Thank you. All right, we're back on the record in 2022 CR 9351 Kayla Rolak. And the court asked the defendant to do a UA. And I'm very happy to say that the UA was negative. All right, is there anything else from either side with regards to argument?
Nothing from the state, Your Honor.
Anything else from the defense?
Well, no, I have a request, but
What is your request?
she's been on the monitor for 5 months. We're asking if it can be removed.
Oh, she's going to remain on the monitor. All right. So, Ms. Rolak, I wanted to tell you, and this is why I always keep an open mind on everything. Just reading your history and looking at everything, someone would suggest that you should go to prison. But, I always tell people whether you think a judge is going to do something or not, and I would always tell my clients, hey, you know what? We have to give the judge something to suggest you're not going to prison. So don't come in and throw yourself on the mercy of the court and you have done nothing. You understand? So I see that you've done a lot. I see that you completed everything with Child Protective Services. And sometimes Child Protective Services, they're always overworked and underpaid, but you actually had a good caseworker to stay on top of you and make sure that you were doing everything that you were supposed to be doing. And I see that you, during this time, you got your GED. You're enrolled in college. That's great. And to all the children who are out there who always think that the best college to go to is someplace that's not at home, sometimes, you know, the best college is a college that's actually in your city. People always want to go to some other college because they think it's the best college. And I always say the best college is wherever you are if you make it that best college. So I see that you've done that. You have supervision because you're not living by yourself. I'm going to want you to continue to not live by yourself. Now, once you've been on probation for a while, your attorney can always come back and ask the court to reconsider that part. So who are the persons you're living with?
I live with my mom
Okay.
and my daughter,
And what's your mom's name?
Brenda Marshall.
I'm sorry?
Brenda Marshall.
Brenda Marshall. And I'm assuming your mom wants you to remain with her.
Yeah.
All right. So this is what the court is going to do. The court is going to grant your application. And I'm actually going to give you deferred adjudication. So 4 years deferred adjudication. There's to be a $1,500 fine. That will be probated. Take in consideration County Court cause number 688-620-691-438, night mag number 675530, proof of employment within 30 days. And in this court, if you're on probation here, I don't allow you to be a home health care provider. So there's to be no employment as a home health care provider with minors. 250 hours community service restitution. Those hours will be waived if you provide proof of enrollment in college, which you have. You need to provide that proof to probation today. And for the court to give you credit for that, you need to take at least 9 hours a semester. And I don't allow people to do that thing where they say, oh, here's my 9 hours for semester, and then they drop classes. That's expensive.
Can I say something?
Yes.
I actually am going for a pre-major in psychology, and then I want to go to UTSA. So after these, I'm going to do I think around 17 hours a semester because I'm.
Thank you. See, when I tell people that every semester I would do 24 hours a semester, people don't believe it, but it can be done.
Yeah.
All right. So provide proof of enrollment in college with at least 9 hours. Probation, I'm going to ask for parenting classes. She's already completed those. So you'll need to provide documentation to that. She is to reside with Brenda Marshall. And so it's only you two in the household, right? All right. There to be no adult males in the household residing there.
Okay.
If something changes, you can let me know. I just found from my experience as a defense attorney on CPS side, what ends up happening is mothers are doing great. And I've had male clients over there too. They're doing great. Then the next thing you know, they end up getting a new partner. They don't vet that partner appropriate and everything that goes downhill. So that's why I'm putting no adult males. So she's not allowed to reside with any adult males. Probation, I'm going to want field visits once per month. Regular reporting, and the field visit can count as her reporting, and that field visit is until further notice. And we'll do regular UAs. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
If, I know you said I could take my certificate that I already did parenting class.
Yes.
Can I still take another one? Because this last one that I took with the San Antonio Fatherhood Campaign,
Mhm.
I actually learned a lot. And if I could just keep learning, because my daughter is getting older.
Okay.
And also, is there any way that I can get, that y'all can help me with like therapy or like getting into counseling?
All right. So what I'll do is probation, we'll add parenting classes. And make sure you notate in that the parenting classes were at Ms. Roleg's request. And also, do we need a mental health caseload or mental health evaluation probation?
What's your mental health evaluation for referral?
All right, we'll do a mental health evaluation for referral.
I did do that, and she said that I didn't have any like things, but I have a lot of anxiety and I just deal with a lot of stress and stuff. So that's why I asked for like the therapy or counseling.
All right, they'll take care of it. They're going to make it happen. If it doesn't happen, let me know.
Okay.
I'm here. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right? All right, good luck to you. Good job.
Thank you so much. Thank you so much.
Oh, you're welcome.
Your Honor,
Yes.
did you specify?
Wait, am I still on house arrest?
Oh. With regards to the monitor probation,
Yes, Your Honor.
let's keep her on the monitor for 2 months. If there are no issues, then it can be removed.
GPS partial.
Yes.
Like, can I take my daughter to the park and stuff?
Yes, it's probation. Just make it tracking,
All right.
but you'll still need to let probation know where you're going to be. Okay.
Okay. Thank you so much.
You're welcome. And this is the top copy is for the state. All right. Thank you.
Have a good week.
Oh, thank you. Just remain she needs to remain in the courtroom so probation can.
In the end, two lives are set on drastically different but structured paths. Mr. Hernandez, with his casual admission of serious drug use, is taken into custody for the inpatient treatment he clearly needs, a stark immediate intervention. For Kayla Rawlig, the verdict is a testament to the power of a second chance, but one that is earned, not given. Facing prison for a terrifying lapse in judgment, her verifiable efforts getting her GED, enrolling in college, and passing a surprise drug test convinced the judge to grant her 4 years of strict deferred adjudication. The judge crafted a sentence that wasn't just punishment, but a roadmap for success, including continued supervision and even therapy at Kayla's own request. It's a powerful conclusion where accountability and rehabilitation go hand in hand. What do you think of the judge's decision? Was it the right call? Let us know in the comments and subscribe for more in-depth courtroom analysis.